All right, calling the matters from our 10 o'clock calendar. Calling matter number 15, Sushant Gupta versus Leanne DeSalvo.
Good morning, Your Honor.
Good morning.
Good morning.
Good morning, Mr. Gupta. Good morning, Ms. DeSalvo. And I believe we have a court reporter here on this matter. If I could have you state your credentials on the record, please.
Sushant Gupta, I'm the plaintiff in this matter.
Sorry, Mr. Gupta, I was asking our court reporter to state her credentials on the record.
Oh,
All right, thank you, Ms. Morin. Thank you, Mr. Gupta, Ms. DeSalvo. The court has not a tentative, but a advisement that this hearing is going to be continued to June 26th, and I'll explain the reasons why. This motion that was on calendar for today was to quash or stay enforcement of a writ of execution. It was filed on April 11th, and one of the bases for the motion is that the court's order granting sanctions back in December was pending. A motion to reconsider and vacate the sanctions award from December was pending, and on May 12th, this court continued the motion to June 9th, the motion regarding vacating the sanctions award, because Mr. Gupta filed a second motion to disqualify this court. And in abundance of caution, the court did not rule on the motion to vacate the sanctions order while the court addressed the motion to disqualify this bench officer. I did rule already on the motion to disqualify me. It's also been ruled on by Judge Riff. This court is not disqualified from the case. But when we continued the motion to vacate the sanctions order to June 9th, there was a clerical error. It did not get scheduled or put on the calendar for June 9th. For some clerical reason, it never got put back on calendar for June 9th. The motion for me to rule on the December sanctions order. So I cannot address your motion that was on calendar for today to quash or stay enforcement of the writ of execution, because I have not yet issued my ruling on the motion to vacate the sanctions award. So June 26th is the next time where we actually have hearings in this case. So I'm going to put together a clear minute order and make sure. So this hearing, we will now be holding it on June 26th, and which is in 3 days. And on that day, I will also put back on calendar the motion that you filed to vacate the December sanctions award, because I need to decide that first before I can rule on your motion to vacate, rule on today's motion to quash or stay enforcement of writ of execution. Okay? So I'm going to
yes, Your Honor, there are a few things I wanted to say. From March, I'm trying to get a relief. It's been 4 months, and there has been no relief for me whatsoever. So I would like to, get this sorted out as soon as possible. I did try to reach Ms. DeSalvo to solve this case, but there's no response from her. On Friday, I did come to the court. I did file for the case management statement, in which I did have contacted 4 different mediators. One is Heidi, one is the Loyola School, to intervene and get this mediated out. I have included that in my case management statement. And then there was one more thing I wanted to ask you, was that on May 5th hearing, I mentioned that I was not on the vexatious litigant list. You did not mention that in your court order. And then on May 7th, you specifically stated that I was not yet on the Judicial Council vexatious litigant list as of May 7, 2025. And you said that the VL 100 form was still being processed and that it takes time for the name to appear on the Judicial Council list. You also acknowledged that you raised this point and said that you would reflect it in your written order. But this was not mentioned in your written order, which I received on the May 9th.
Okay. Well, the court, again, maybe had a clerical error, but if on the record, I did state that you raised the issue that you were not on the vexatious litigant list. It did not appear that you were. The court checked into that, and it appeared the VL 100 had been sent. There was just a delay in getting you on the list. But once the court has a VL 100 form and it's been sent, you need to be put on the list. So the court looked into that and verified that there was nothing that had not been done on our end, on the court's end. I was not here at that time, but we verified that there was a VL 100 requirement that you be on the list, and so you are now on the list, as far as the court knows.
So can you tell me, like, what day was it transmitted? What day was the VL 100 transmitted to the Judicial Council list?
Well, looking at the docket, there's a certificate of mailing, I believe. Let me just look. Okay, it looks like the VL 100 is dated October 14th, 2024. It was signed by Judge Wyndham. And then there is a certificate of mailing dated October 14th. Or actually, it's dated October 15th, 2024. So that's when it was mailed.
October 15th it was mailed. Okay. And you see the address on the VL 100 form, PO Box 2028. I did not provide that address to the court till March 25th, 2025. So
Okay, that's subject
I
to
don't know.
a number of your motions that you have repeatedly filed. So those issues will be addressed at that time. Today, the court is putting in the minute order a clear reflection of the record. The motion under CCP 473 to set aside judgment or order, which was filed on April 1st, is being continued to June 26th at 10 o'clock. The motion to quash or stay enforcement of writ of execution is being continued to June 26th at 10 o'clock. The motion for sanctions in the amount of $21,500 against Gupta for filing frivolous motion to set aside judgment, that's on calendar to be heard on June 26th, as is the amended motion for sanctions against Gupta for filing two frivolous appeals on 3/10/2025 in the amount of $47,500. those matters have been fully briefed. No further briefing is to be filed on any of these matters, but they will be heard on June 26th, 2025 at 10 o'clock.
Okay.
All right. I will see you.
And then,
I'll see you both then.
and then I just wanted to say one more thing that Mr. Brainard never filed a substitution of attorney for Kristen Leahy and not even for Intuitive Healing Institute LLC. He never had an authority to represent himself either for Intuitive Healing Institute LLC and not for Kristen Leahy either. He never filed. He never paid a fee for Kristen Leahy. Kristen Leahy has two houses, one in Los Angeles, one in New York. And for LLC, also you need to pay the court fee, which he never paid. He never filed a substitution of attorney for Intuitive Healing Institute LLC either. And for the sanctions, you approved the sanctions. He in a sanctions motion, he was asking the fee for Kristen Leahy when he is not authorized to. Plus, you haven't mentioned Kristen Leahy in your order either. And Ms. DeSalvo has a fee waiver, so she cannot get any money. And for Intuitive Healing Institute LLC, he hasn't filed a substitution of attorney either. He has done a huge fraud with the court.
All right. So the court, this is post-judgment, so the court will set an order to show cause regarding substitution of attorney as to Intuitive Healing and as to Kristen Leahy. This is post-judgment. At the last hearing where we were here, Mr. Brainard represented he was withdrawing the motion with respect to motion for costs or request for costs as to Kristen Leahy. So he withdrew that motion. I don't see that he's seeking anything further, but if there is anything further being sought, this is again post-judgment. I don't see that Ms. Leahy has requested or has sought ongoing relief from the court. The last hearing where we were here, Mr. Brainard withdrew the motion to tax or the costs, memorandum of costs as to Ms. Leahy. So I don't see that he's been having any ongoing, or that Ms. Leahy or Intuitive Healing have had any ongoing requests for relief. This has all been Ms. DeSalvo. But I'll set an order to show. I'll set an order to show.
And if you see his substitution of attorney where he subbed off from the case, there's only Leon DeSalvo mentioned. He has not mentioned Intuitive Healing Institute. He has not mentioned Kristen Leahy. He never represented Kristen Leahy. There is no appearance by Kristen Leahy. There is no fee paid by Kristen Leahy. It's all bogus. It's like,
right. The court will set,
I don't know what.
The court will set an order to show cause regarding whether Mr. Brainard needs to be substituted out regarding Kristen Leahy, and that will be set for July 29th at 10 o'clock.
But he never substituted in.
That's what I'm.
He never substituted.
Those issues issues will be addressed at the order to show cause on July 29th, 2025. The court clerk will give notice because we have a number of other hearings on that date.
No. Yeah, exactly. So what date? Okay, I have the date. Okay, and then if you can give me the information of the court reporter, if possible, their email or phone number or something.
I don't have her email or phone number, but the court reporter put her credentials on the record. Deborah Morin, CSR.
DEBRAMOREN.
Deborah, DEBORAH.
And then MOREN.
IN.
Morin.
Right. Anything.
And yeah.
I'm not asking. I need to hear from Ms. DeSalvo. Anything you'd like the court before we go, Ms. DeSalvo?
Yes, ma'am. In regard to mediation, Mr. Gupta and Mr. Bernard had gone back and forth week after week trying to settle. Mr. Gupta's main concern is for us to take him off the vexatious litigant list, which I believe isn't possible. I believe Judge Wyndham has to do that. So I really don't understand why I'm being barraged with emails and filings on mediation. I really just don't see the point. Mr. Gupta has refused everything we've offered. He's asked for ridiculous demands. He's asked for us to let go of the sanctions so he would stop filing things against us, which is actually threats, just as a vexatious litigant would do. He's been proven to be a vexatious litigant. The sanctions were because he's a vexatious litigant and filing numerous meritless paperwork. He has no regard for your orders, and he never will until you choose to enforce them. He has already filed 2 cases in Orange County, which are no longer in force. However, he filed them knowing full well he was declared a vexatious litigant. So whether he was on the list or not, Mr. Gupta knew these things and did it anyway. He's also filed numerous documents in spite of the pre-filing order. Again, he completely ignores your orders, and he just will not stop until they're enforced.
Okay. Thank you, Ms. DeSalvo. The court has been reviewing Mr. Gupta is required to come into court to file documents. If he's filing them in violation of this court's May 5th order, they will be rejected. He has to do 14 days of notice. He is aware of that. Mr. Gupta, I will admonish you that you continue to file ex partes in violation of the court's May 5th order. So those will continue to be rejected. You are only permitted to file regularly noticed motions that comply with the May 5th order, that you give 14 days to the court to review those before they go on the docket. Again, I will reiterate the May 5th order that if you file anything in violation of that order, it will be rejected in conformance with that order. Okay? So you are on notice. You've been on notice since May 5th of what you have to do before you file anything. If you're filing it in violation of that order, it will be rejected. Okay?
Ma'am, the actually thing is that both the Orange County cases which I filed, I did file the VL-100 form. And the vexatious litigant thing which she's saying, it is the pre-filing was in the favor of Kristen Leahy, and Mr. Brainard never ever represented Kristen Leahy. He never ever represented Kristen Leahy. There is no substitution of attorney. I haven't filed anything frivolous. I have only filed everything related with the case. And Mr. Brainard, what he offered was one-sided settlement. He said, we will take off the $23,816, okay? We will not take you off the vexatious litigant list. And if you, anyhow, in the future, say anything to Lee and DeSalvo, to me, or to Kristen Leahy, we will come back full force, and we will put the $23,816 on you again as a sanction. That's what he offered me.
Your Honor.
Okay, I can't.
Yes,
I'm not conducting a settlement conference today. I hear what everyone's saying. I do want to point out that the only person who has the ability to remove Mr. Gupta from the vexatious litigant list is Judge Wyndham. The Code of Civil Procedure, the legislature, the law has made it very clear what the process is for removal from vexatious litigant lists. That is not something this court can consider. You've been repeatedly told that. Mr. Gupta, you can't continue to bring those motions to the court. This court cannot rule on that. I have no power from the legislature. Has made it clear that it has to be to the judge that declared you. So all of these arguments that you're raising have to be put in a motion under follow the law. That is all the court is expecting you to do. Read the law, follow the rules, file your motions that comply with the procedures set forth by the legislature, by the courts, by the Judicial Council. You can't just keep filing these motions and different pieces of documentation that you're hoping the court will grant you relief. You have to follow the rules of court. Being a self-represented litigant does not exempt you from following the rules of notice, of procedure, what the legislature has set forth as the requirements for how you get off of a vexatious litigant list. This court cannot consider those motions. You've been told that by this court, by Judge Riff. You've been told that repeatedly.
Ma'am, but I told you that Mr. Brainard never filed a substitution of attorney, and that's the reason he filed 2 requests for restraining orders against me, so to shut me up, because because he knew that sooner or later I will come to know that Miss Lee and DeSalvo did a big fraud with the court. They never paid a single fee to the court. LLC is required to pay the court fee. Kristen Leahy was never represented. So that pre-filing order for the vexatious litigant, that is void.
Okay, I can't. You take that to Judge Wyndham. I cannot consider those arguments. That has to be filed under the rules and the law. The legislature has made it very clear. You've been quoted and cited the Code of Civil Procedure that tells you who has the jurisdiction. I have no jurisdiction to consider your arguments that you are making here today. No jurisdiction. These arguments have to go to Judge Wyndham.
So in the last hearing, I think Mr. Brainard came back to you after he disconnected the call, that his modus operandi, and he told you that you cannot overturn that decision. That was, he told you that, right?
No.
He came back and he told you that, not to do that, because in the last hearing you said that you will be, on June 18th, you will be conducting a settlement conference, and you will be able to overturn the vexatious litigant ruling.
No,
that's what you said, remember?
What I said is I don't even know if I have authority to do that, and that was one thing you were asking for on the request for a settlement conference. I said I don't even know I have authority to do that, and I don't. The Code of Civil Procedure is clear, so I can't have a settlement conference, which is why the court issued a minute order. After my hearing, I reviewed the law, and it's been clear I have no authority. We cannot have a settlement conference where you're going to get the relief that you seek. So that is why the court issued a minute order. After we had the court hearing, where I decided and made it clear, upon further reflection, the court, on its own motion, decided that I cannot hold a settlement conference because the relief you're going to seek at the settlement conference, one of the reasons is that I decided it was not best for me to hold a settlement conference, is I can't give you that relief. So that's what my minute order says. It does not say anything about the VL 100, but for those reasons, the court decided I could not hold a settlement conference. In addition to other, it was on my own motion. No, there was no ex parte communications from Mr. Brainard. It was the court's own motion.
Okay.
All right. So
can you set up a hearing with Mr. Wyndham for me?
I cannot do that. No. You have to follow the rules of court and procedure, and follow and file regularly noticed motions that take into account the court's May 5th order requiring you to give notice and an opportunity for the court to consider your motions before they go on the docket. So.
And then would you be able to lift the May 5th order for me to come in person? Because as you know, there are protests going on in Los Angeles. I've been there already 15 to 20 times. I have to drive all the way from Fullerton. It's traffic, and I have to come in person. I have to print the paper. It costs me money. I have to pay for the parking. I have to walk all the way to the security. I have to go to the second floor. And it's a lot of work.
Mr. Gupta, you've demonstrated that you continue to refuse to comply with the court's May 5th order. You have not demonstrated to me that you will follow it. You continue to file ex partes. You continue to file motions that are not regularly noticed, that do not take into account the court's 14-day requirement to review those filings. So no, because you have not demonstrated that you can comply with the May 5th order, you are not relieved of your obligation to follow it and to file documents in person. Until you demonstrate that you can comply and follow court orders, the court will not be lifting that May 5th order.
Ma'am, for July 1st and July 2nd, I did file 2 regular motions which you vacated. And after that, I filed the ex parte. Because I don't have so much of time, I have to go to India. I have to do other things as well. It's been almost a year I've been engaged in this case like day and night. And then coming to the court and filing in person, that's like an added burden. There are protests going on. They are throwing stones over there. I can get killed or injured over there.
Okay, the court has considered that. The court has remained open. The operations have remained ongoing as normal. There has been no interruption to this court's operations, given the ongoing demonstrations happening. There are peaceful protests happening outside of this courthouse. That is what this court has observed, to the point where we've been able to maintain. We have not had to close. We've continued operations. The court has remained accessible to you and to all litigants up to this point. So the court does not find that that is a basis to lift the May 5th order either. So the court will be issuing a minute order to just make clear what we are hearing.
You want me to speak for a moment?
Go ahead.
Sorry?
Mr. Gupta filed a lawsuit for $175 against me. In his documents, he has proven repeatedly that I gave him the service he asked for.
No, you did not.
He released.
Mr. Gupta, I'm going to have to.
Okay.
You know, you've been here numerous times. You observe other attorneys and litigants appear. You do not interrupt each other. Ms. Liz DeSalvo has been very respectful. She lets you speak. She doesn't interrupt you. Take notes. If you want to respond to whatever she says, wait your turn. Go ahead, Ms. DeSalvo.
Thank you, ma'am. He dropped the charges on me last year. He was determined that vexatious litigant and sanctions were put on him. Throughout this year, the only reason this has continued is because Mr. Gupta keeps filing more and more and more documents. Mr. Gupta, he keeps professing that he's a victim, when in fact, I'm the victim. I've been put through this for a year, when this case should have ended last year, when he was declared a vexatious litigant. In this case, for the past year, he has proven over and over and over again that he's a vexatious litigant. So with him coming up, with him being a blood pressure patient, not being able to go downtown, perhaps it's because he's not legal. Maybe he's afraid of ICE. He has to go to India.
That's a threat. No, I'm a citizen. I'm a citizen. Hello, don't make
okay.
What afraid of ICE? I'm not afraid of ICE, okay?
The court will not
have some manners.
The court
have some manners. I'm a citizen, okay? I'm a citizen of the United States.
Mr. Gupta, you're demonstrating your inability to comport yourself with the court procedures. Mr. DeSalvo, the court will also not consider additional arguments based on race or immigration status. Those things are not relevant to this court's proceedings.
Thank you. I apologize.
You can see, like, she's
okay,
the healer.
The court is going to go into recess because the two parties here cannot conduct themselves in accordance with the rules of court. Court is taking a break and a recess. I'll come back in 5 minutes and see if the two of you can stop talking over each other.